And again, good evening, everyone, and welcome to WSN Men Live. My name is Chris Bentley. I'm the Managing Director of Widowers Support Network, and I'm so grateful that you've joined us tonight. Before we begin, just a couple of housekeeping notes. This session is being recorded, as you just heard. So if you'd prefer to keep your cameras off, that's completely okay. It looks like you're all muted. For Q&A, if you have questions, certainly feel free to unmute, or I can unmute you. But we're also going to be using the chat feature, so feel free to submit questions at any time using that. I'll be monitoring questions throughout the conversation, and if there's some, just whatever hits you, just go ahead and drop it into the chat. We'll try to address it as we go, but otherwise, we'll try to catch it at the end. We have saved time. We have saved time for some Q&A at the end. So again, thank you for being here tonight, and I'm grateful that you chose to spend this time with us, and hopefully it will be of a benefit to you. So tonight it's my honor to welcome Tamara Block, otherwise known as Tammy. She's a licensed attorney in Minnesota. She was admitted to the bar in 1998. South Dakota, she was admitted there in 2000, and then finally in Tennessee, where she is joining us tonight. She was admitted to the bar in 2023. And she has a practice that serves clients in a relationship-based model. I should know that because I think I've been a client for about 20 years? I think maybe longer.
Almost since we started.
So as you can see, we have a relationship, and so I think it works pretty well. She has over 20 years of legal experience working with clients in estate planning, real estate, nonprofit, litigation, small business matters. So a lot of experience to share with us tonight. Her goal is to provide families and individuals with a sense of security and to make the process easy to understand by being proactive in their legal matters. In addition to her legal background, Tammy has a family business background to assist business owners with their estate planning needs. And although she lives in the Twin Cities area, she travels throughout Minnesota and Tennessee, and I guess South Dakota as well, to assist clients in person as needed, and she's available virtually. So welcome, Tammy. Thanks for joining us all the way from Tennessee. And with that, I guess I will turn the mic over to you.
All right, perfect. Thank you for the introduction, Chris. And so, as Chris said, I'm licensed in those three jurisdictions. A new one got added, Chris, Texas. So the information I'm giving you here is general information. It may or may not apply to whatever state that you are living in. So I do try to give general, although there are state-specific items that sometimes crop up. For instance, in Tennessee, I need to do some things a little bit differently with some of our small businesses. Also, in some of the states, we have transfer on death deeds, which I'm going to talk about, but not all states have them. So as those things come up, I will kind of point out some of those are state specific versus general. So I just wanted to give that caveat. The attorney has to give the warnings up front, right? The caveats up front. So with that, Chris is driving for me tonight, so I will have him click to the next one. Okay, so what is an estate plan? Everybody thinks an estate plan is a will. I need to have a will, and they believe that they have to be wealthy to have an estate plan. You do not have to be wealthy to have an estate plan. Everybody should have an estate plan. An estate plan truly is ensuring that your legacy, what you have worked for, passes on in the direction that you want it to pass on. An estate plan also makes things easier for your family once you are gone. It makes sure you have your I's dotted and your T's crossed. And that estate plan includes, at the very least, a power of attorney, a healthcare directive or healthcare power of attorney, depending on what state you're in, and a will. Could be a trust, but we also review beneficiary designations and also business succession plans. So I saw Andrew had a question as we're popping up. Yes.
Can you read that?
Yep, I can. So for those that might not be able to access it, Andrew asked, adding a sibling to your checking account to only pay bills if necessary. He wanted my thoughts. Is a POA only, do not wish sibling to be an owner on the account. So you can either make your sibling a signer, which is not an owner on the account, or you can use a power of attorney. The issue is if you only make them a signer on the account and you don't do a power of attorney, the only thing that they can do for you financially is make payments out of that bank account. They can't like contact a utility company and ask questions about any charges. They can't talk to an insurance company about any payments or bills that might be coming in. So, a power of attorney very generally allows them to act on your behalf in anything financial and legal. I do have people that are concerned about people having that authority. Um, they do have to follow certain rules and regulations. And I will tell you in this day and age, many institutions, many places are very, I would say, almost overwatchful regarding any abuse of their power of attorney role. I had a client, she was a client of mine in Minnesota. She had power of attorney for mom. She brought mom into the bank with her. So mom was physically with her. Mom was withdrawing cash. It was Christmas time. She wanted to give each of the grandkids $250. The banker was worried about undue influence and called the sheriff's office. The sheriff's office appeared at the house the next day to question mom. Needless to say, it went away very quickly. But I do tell people if you're worried about a power of attorney form, please know that those are scrutinized very highly by anyone that is on the receiving end, banks, insurance companies, or anything like that. But if you do put them on an account, then they can only help you with that account. They can't help you with everything else. But I agree, do not make them a joint owner.
Hey, Tammy, while we're on this subject of checking
Absolutely.
accounts,
Yeah.
um, he's got a follow-on question. Does the POA need to be registered with the bank?
No, it does not. As long as they know where your copy is. I do tell people if you register with it with the bank, it saves your power of attorney a step, but it does not have to be. Just as long as they know where you keep it and they can access it when needed. What was Chris?
Yeah, I was just while we're on the checking accounts, those
Yeah.
are that's great understanding kind of how to manage that as a single person, right? But then how do they protect themselves in the event that when they pass on, that doesn't get caught up in probate and all those funds get tied up? Because there's another step they could take now to help protect in that eventuality, correct?
Absolutely. So, with bank accounts, and you're going to hear different words, but with bank accounts, you can do a transfer on death designation for your bank account. So, it essentially is a beneficiary designation, but they don't call it beneficiary for bank accounts. So, if you do a transfer on death, then when you pass away, because we all pass away at some point in time, when you pass away, those people that you have named or person you have named to receive the assets from your bank account just have to take a death certificate into the bank, and the bank closes out that account and distributes those as you have designated in your transfer on death. And that's one of the ways you can avoid probate. And then Andrew asked, does sibling need to bring a copy with them? Yes. So if it's not already registered with the bank, the sibling would have to bring it with them. If it's already registered with the bank, then all the sibling needs is uh, their ID. And yes, it's payable on death or transfer on death designation, Andrew.
Great, thanks.
Absolutely. Next. Next slide. Absolutely, Andrew. So who needs an estate plan? And what happens if you don't have one? Everyone needs one. I said that already. It's to plan for the expected. We all know we're going to pass away. So it's planning for that and to plan for the unexpected. I just had a situation in Minnesota. I have a client there. She's 78. She runs triathlons, perfectly healthy. I am her personal representative, but she has a friend as her power of attorney. She has a nephew as her healthcare agent. And I visit her every quarter. In October, I visited her. She was fine. I visited her in February, and there was something very wrong. She cognitively was not aware of anything. And so we immediately, within 5 days, had to have a well check with her, had to get her into a medical facility. And she had some kind of psychotic break. And we had to get her treated. And she was in the hospital for 8 weeks. She just got out. And so none of us would have seen that coming. Very, very healthy individual. She's a widow. So again, planning for the unexpected, we had all of those things in place. So we were able to step in. We took care of the bills. We were able to get her the health care she needed, all of those things. But without those, there would have been court intervention and someone would have stepped in to take care of her. That was not somebody she had chosen. Obviously, to transfer your assets wherever you would like them to go. Also, charitable intent and philanthropy. If you don't have an estate plan in place, there is what I call a decision tree. Your assets don't go into Never Land, but if you do have charitable intent, that won't be followed unless you have your documents assigning those. Again, assistance while you're alive but incapacitated. In some states, business succession is very important. Tennessee is one of them. They have very specific rules. I'm an LLC. There are very specific rules about how my business can be wound down in Tennessee versus Texas or Minnesota. And for those people that have minor children, one of the most important things is establishing guardianship for their minor children if they should pass away. Because if they don't establish guardianship through there, the courts get to decide who may be the guardians, and it may not be whom you wanted. So that's one of the big things I tell people as young parents even if you don't have a lot of assets, the guardianship of those children is one of the things you want to be sure to take care of. Next slide. Oops. Later in the session, briefly discuss the cost of having an estate plan. Definitely, I'll make a note and we can address that. Keeping your estate plan up to date. So one of the things I tell people, and Chris knows how I operate, traditionally, and I will tell you with most attorneys, you do these documents and they're put on a shelf. The attorney never follows up with you and you don't ever think about them again. I review with my clients annually. So as Chris has said, he's a client of mine, so I'll share with him, with you all. Every year we send to Chris, hey, it's time for your annual checkup. And we have a checklist and it says, have any of these things happened? If they have, then please contact us. But even if they haven't, I'm happy to meet with you. So I have some clients that meet with me annually. I have some that only meet with me every 3 to 5 years, and I have some that only meet with me when they have a change. I do have some attorneys that I know that do it every 3 to 5 years, but the majority of the attorneys are still in that camp. I did your documents. If you need anything else, call me, and they charge you every time they pick up the phone. So I would say these are living documents. You need to stay on top of them. I also say it's good to review them with your accountant, your insurance agent, your financial advisor, your family as needed. There are times where I will recommend let's review this. Let's work with your financial advisor. Chris knows that as well. I like to work very closely with those people. I see us as a team. I'm not acting all by myself. It truly is a team. Some of the major times that you really need to update your documents is, marriage, either yours or your children's marriage, because that might impact how we have them receiving their assets, births of children or grandchildren, deaths of any immediate family members, beneficiaries, or even people you named as your personal representative, power of attorney. If you should receive an inheritance, that becomes very, very important in the state of Minnesota. Tennessee, Texas, and South Dakota do not have an estate tax. Minnesota does, and it is a very low threshold. I say low threshold. Um, I have young families that each have $1 million life insurance policies, and because of that, with their other assets, they already are at the estate tax threshold. So receiving that inheritance might be something we need to look at. And if you've sold major piece of real estate or business interests, we want to adjust accordingly. Next slide. So I'm going to talk first and foremost about the healthcare power of attorney. In the state of Minnesota, it's called a healthcare directive. In the other states I work in, it's called a healthcare power of attorney. Um, these are very, very important for my widowed clients. Even under HIPAA, HIPAA's been around for 25 years. Under HIPAA, a healthcare practitioner is not supposed to talk to your spouse. They are not supposed to give out any information or anything like that. They still do. And for practical purposes, most of the time it works. You'll hear these weird cases where, the spouses were estranged and somebody takes them off life support, the family sues. But in most cases, it works fine. But now you've lost that person, and so you need to designate a new person. Again, for the most part, healthcare practitioners will defer to your adult children. But however, sometimes that becomes a conflict between your adult children. I can tell you my mom is one of five. And when my grandmother was going through end of life, the youngest didn't didn't want to remove her from life support. And I mean, it was not quality of life, but that created issues. Thank goodness she had a healthcare power of attorney so that the two older children were the ones that had the final say. And, ultimately he came around, but I've seen that happen. So the healthcare power of attorney isn't just to make sure that your wishes are fulfilled, but it's also to help the family to designate who that might be and being very thoughtful about the person that you designate because you need to be sure that that person feels comfortable following through on your wishes. I've seen that happen too, where they'll name just the older child and the older child doesn't feel comfortable removing life support. So you want to always be sure that the person you have chosen feels comfortable making your decisions because the only thing that is binding on the healthcare practitioners is that person acting as your healthcare power of attorney. If they see in your healthcare power of attorney, you want, no ventilator, they can't just take you off the ventilator. They literally have to have your healthcare power of attorney approve that. So you need to be sure that that person feels okay making those decisions. And it also allows you to put some of those decisions in writing. It can be anyone that's 18 years or older. And so I will also say with my young families, and I just had an email before I got on here, you really need to have this for your children once they hit the age of 18. This is one thing that healthcare practitioners in this day and age are very stringent about. Chris knows my kids. And my son was a little unusual. He played varsity football for 3 years and he played both sides of the line. So he played 60 minutes of Friday Night Lights for 3 years. So you can imagine his body was a little beat up by the time he got done his senior year. And so a month after his senior year, or a month after he turned 18, football season was done. 2 weeks after that, we were in surgery. They would not even give to me the time of the surgery. Now, we had one of these, we just forgot to give it to the doctor's office. So, if you have children that are 18 or over, college age, be sure that you have one of these for them because if something happens to them, you are not allowed to make any decisions on their behalf. And I will tell you the opposite of when you're older and they defer to your children, it is not the case when your kids are 18 and you're the parent.
So, Tammy, not everybody has somebody, and there is
Yeah.
a legal alternative to having somebody. Could you just, and is that true in all states as well? It's not. Okay.
Yeah.
Um, but again, we've got guys from all over the country and a few from around the world. So I know it won't always apply, but I think one of the concerns I can hear that, right, the wheels turning. Well, I don't have siblings and I don't have an older child. And what am I supposed to do then if I want to protect myself? What's the answer?
So, it does depend. I did have in Minnesota, I did have that, and they were able to, there are agencies that will assist with that. We have a really good one. I don't know if you've worked with them at all, Chris, but Lutheran Social Services in Minnesota offers this service. I actually have two of my clients that I've become close to who don't have anybody, and I've offered to do this. I will tell you, attorneys are more comfortable acting as a power of attorney for legal than they are healthcare. It's just that I've known these two women. Neither one of them were ever married, and I've known them for many, many years. And so I've taken on the role more as a friend. But Minnesota does have those options. I can tell you, like in Tennessee, those are very limited. I know they do have options in South Dakota as well.
Okay.
Good question. So, power of attorney. So, we just talked about the healthcare power of attorney. This is your financial power of attorney. So, this is what we talked about with the bank. This is the person that is able to handle your financial and legal affairs, including business affairs, if you have a business. So, anything you can do for yourself. Um, the nice thing about this is you can do it for a term. I've had clients, they were going to go to Europe for 2 months. And so they gave a power of attorney for the time that they were going to be in Europe. But you can also do it for incapacitation only. So it is very important, even with married people, that you have a power of attorney. Because a married person, even I tell people, there's this myth out there, well, my spouse will be able to handle everything. Anything that are individual accounts, so like individual retirement accounts, individual life insurance accounts, your spouse cannot gain access to those. Even utilities, if utilities are in one name or the other. We ran into this actually in Tennessee. We needed to do a change on something, and I'd been the one that did the utilities, so they put it all in my name. My husband, they wouldn't even take the call from him. So I tell people, even married people need to have this, but this power of attorney for people that aren't married is a lifesaver. I've had this done for people, and literally something has happened within 3 or 4 months. And I've had the family come back to me and say, oh my gosh, that was the most useful tool we could have had because they were able to step right in with banking transactions, talking to insurance companies, talking to the assisted living billing office. So I will tell you, I tell my clients if you do nothing else, um, at least do this because it is the most useful document that you can have.
And this ends at death, right, Tammy?
This ends at death. Yep. So this goes away at death. That's a question I get a lot of times. Family members will come to me and say, well, mom passed and I tried to use the power of attorney at the bank and they wouldn't let me use it. And so it does end at death. Um, yes. So
You're
and
gonna
yep, and you asked about trusts. Yep, I will definitely talk about those. We
all
have
right.
plenty of time. Good.
Do we have to talk about durable power of attorney at all?
Yeah, so what I will tell you is there's durable powers of attorney and not durable powers of attorney. They become more important in some states rather than some others. So, like in Tennessee, your power of attorney doesn't go into effect until you're incapacitated. So, what a durable power of attorney means is it endures your incapacity. So, if you become incapacitated, it stays. Well, in Tennessee, powers of attorney don't even get activated until then. But in Minnesota, they can be activated right away. And in Minnesota, it's very important to actually do that because what we have found in Minnesota is healthcare professionals are not willing to deem somebody incapacitated for legal reasons. So part of it comes down to a culture issue, but that's what a durable power of attorney is. And so I always say if you get one, be sure it's durable, and have the attorney show you where the document says that. So on in the Minnesota one, for instance, it's Article 2 of the power of attorney. In Tennessee, it's literally on the first page. So be sure that whomever you work with, they show you where it says it. So you are guaranteed it is a durable power of attorney.
Great. Thanks, Tammy.
Absolutely. So what happens if you don't have a will? The court decides who makes decisions on your estate's behalf. So they appoint your personal representative. There is a hierarchy. And so I tell people this was actually, I didn't know I was going to go into estate planning when I took the bar, but I still remember this question. So they have a hierarchy. If you don't have a will, they have to name a personal representative. They go to your spouse first, obviously. If you don't have a spouse, they go to adult children. And if you have more than one adult child, the court gets to decide which of those adult children, which can start litigation right there. I just had one of those last month in Minnesota. If you don't have adult children, it actually goes to your parents. I've had that happen where it was a 97-year-old mom. And so she was like, I don't want to be personal representative. Then it goes to siblings. So there is a hierarchy, but it might not be whom you chose. So now there might be somebody in that position that isn't possibly the best person to be in that position. And it might also create a little bit of discontent amongst the family on who was chosen. As I referenced before, if you don't have a will and you have minor children, or you have adult children that you are a guardian for. I was on a meeting just before this one. We were establishing a supplemental needs trust for their daughter who has special needs, and they are her guardian. So you can also appoint a guardian for an adult special needs child in your estate plan. It does take longer to settle your assets. And that depends too. I will tell you, in Hennepin County in Minneapolis, if it is pretty straightforward, I can still settle an estate in 3 months, but that's rare. That's very rare. And then again, there is that same tree of succession about who inherits what. And so, if you don't want your 97-year-old mother to inherit, because you're not married, you don't have any children, then you need to have a will in place to do that, or a trust, as we will talk about. One of the myths that I hear a lot of is I need a will so I don't have to have probate. A will does go through probate. Probate, the true purpose of probate is what we call proving of the will. You can't just take the will to go to the bank and say, you know what, my mom appointed me personal representative and the money goes to us siblings. That's not how it works. There would be wills that people would just be taking every which direction. It literally has to go through a court process to be proven. There has to be legal notifications done. So a will does not avoid probate, but it makes probate cleaner, is what I tell people. All right, so let's talk about trusts a little bit. The purpose of trusts, I tell people it used to be that trusts were much more common in some jurisdictions than they are now, and I'll explain why. There are still some states where I would say, please, please do a trust. California is one, New York is one, just because their probate process is just horrible. Like I said, Minnesota's, we can get through pretty streamlined with a will. You cannot do that in some of these other jurisdictions. But when somebody comes to me in, Minnesota, South Dakota, and Texas, if they have minor children, I recommend a trust. Because then that money is put aside, it is kept safe for those children, and it can be distributed over time so that you don't have 18-year-old children um, getting, big lump sums of money. I talked about adult children with special needs. We would do a special kind of trust for them. Also, if you have property located in another state, a trust is good because you don't want to go through what we call ancillary probate, which is probate in multiple jurisdictions. That really complicates things as well. If you have more complicated distribution of assets, I do have, and I'm actually working on one now. I have a meeting with her next week where I will have people that have 20 beneficiaries. And so to go through the probate process, notifying 20 beneficiaries is very cumbersome and very expensive. So a trust streamlines that a little bit, and it does avoid probate. In some states, we can avoid probate altogether if it's very simple. So, like in Minnesota, if somebody comes to me and we have a what I call a simple family. 2 or 3 adult children. There's no special considerations. We can do payable on death for, financial accounts. We can do beneficiary designations for retirement funds, life insurance. And in Minnesota, we have something called a transfer on death deed, which acts as a beneficiary designation for your home. All of those beneficiary formats help us to avoid probate. So we don't need a trust to avoid probate. That is the same with South Dakota and Texas. Tennessee does not have a transfer on death deed. So in Tennessee, the only way to avoid probate if you have real estate is to do a trust. There are a
Hmm.
few other complicated ways in Tennessee, but we don't want to have to go down those routes. So, transfer on death deeds are only legal in 28 of the 50 states. So, if you are in one of those states, Florida is one. Florida does not have transfer on death deeds. A trust is the only way to be able to avoid probate. So, the question was a living trust and a revocable living trust. Those are actually the same thing. So, a living trust and a revocable living trust are trusts that are established during your lifetime, that during your lifetime you can revoke. You can change them or amend them. Those are the most common, and those are really used to avoid probate for those more complicated assets. And those revocable living trusts become irrevocable when you pass away. So they cannot be changed once you pass away. There are a number of other types of trusts. In Minnesota, we have to do what are called AB trusts to help minimize our estate plan, our state taxes. We do have irrevocable trusts for certain reasons in all states. We do have supplemental needs trusts for children with special needs. The most common is the revocable living trust. Um, I do with my revocable living trust, I also do a will. Your will is your backup because I've had so many clients of other attorneys that have come to me. They did the revocable living trust. They didn't get everything into that revocable living trust or designate that trust as beneficiaries. And now they're going through probate without the will. And remember what happens if we're going through probate without a will. It's a mess. So I do a will as well as a trust. Will with joint tenancy, those aren't done any longer. There are always separate wills. And so I think that's what your question is, Andrew. It used to be that you could do joint wills, a joint tenant will. Those aren't done any longer. Each person, spouse, has a will. Um, Property we can pass with joint tenancy, obviously. So you can still do that. It acts almost like, joint ownership of a bank account or property, but wills are always separate now. And a beneficiary deed, in some states, they're called beneficiary deeds. They're also called transfer on death deeds, but some states have a certain type of deed and they call it a beneficiary deed versus a transfer on death deed, but it's the same concept. You're naming the beneficiary for your real estate without having to go through probate.
Tammy, so question,
Yeah.
um, guys, let's just assume that the home was jointly deeded. Both names are on there. Is there any harm in not changing that? Um, Leaving it the way it is? Uh, or should that, unfortunately, the spouse who passed, removing that name and perhaps setting up, as we're just talking about, this transfer on death or right, a beneficiary deed, setting that up. That's something they have to actively do. It just doesn't happen. They would have to go do that. And when do they do that at the county level? Is that where folks go to do that?
Yeah, it's at the county level. I will tell you that is state specific. So Tennessee, in Tennessee, you just have to produce the death certificate and they'll remove them.
Mhm.
In Minnesota, you have to actually do a form called affidavit of survivorship and submit that with the death certificate. In Tennessee, there's a form you also have to submit with the death certificate. South Dakota, you just have to do a death certificate. The county recorder's offices are really good. If you went in and just said, they can't quote give you legal advice, but they would say, hey, here's the form. And so that's done at the county level. I tell my clients, In those states, with a transfer on death deed, you can't do the transfer on death deed until you remove the spouse. Um, in Tennessee, when we use a trust to avoid probate, they allow us to do it all at the same time. So we do a deed to the trust and submit the death certificate at the same time. Versus Minnesota, you have to do one before you can do the other. So in Minnesota, if you want to avoid probate, you have to do it that way for sure. Whereas in Tennessee, they allow us to do it all at the same time. So it really does depend on the state. How does that affect the loan on your house? It does not affect the loan on your house in any way, either way. If you do the transfer on death deed, it acts as a beneficiary designation. It's not changing ownership interest. And if you do the revocable living trust, it does not impact your loan because you still have control over the house because it's a revocable living trust. If you did an irrevocable trust, that would then call the loan. And so that's why those are done very rarely and only in special circumstances. But a revocable living trust doesn't change your loan at all. And you're still personally liable for it, and nothing happens as far as calling that. And you're in Missouri,
Missouri?
transfer of real estate can be done, but must be established before death. And I don't know. I'm not licensed in Missouri, and that's kind of why I preempted this by saying there are ways in some states, but not all states. And I can only speak to the four I know, and then some others that I've had clients move to. So that might be something. California does have transfer on death deeds, so you can do one, Mike, in California.
Yeah, I guess, you're just underscoring the point of how every state is different. Finding representation in your state is just critical because
Yes.
as much as we, kind of talk about the universal truths, there are always the caveats and the exceptions and the different form. And
Yep.
so this isn't something you should be navigating on your own. You should definitely be working with an estate planning attorney. I think if I take one thing away from tonight, it's how complicated it is. I mean, it makes sense right up here, but when you start getting into
Yeah.
the weeds about what you need to do to actually affect this and protect yourself, you need legal representation in your state that understands the laws. And I guess how does somebody pick if somebody's not needed an estate planning attorney before now?
Oh,
I mean, maybe there's a will, maybe there's a trust, but maybe now, I mean, like we're encouraging them to go revisit that, right? Death was one of those,
yes.
unfortunately, one of
Yes.
those times when you should really be revisiting this, which is really why we're here tonight. How, how does somebody know they got a good one? Like I know you're a good one. How do people know that? Is there a
Um,
way?
use your family and friends. Don't go to seminar and trust me, I give talks like this all the time. But don't go to seminars, don't Google it, don't, people can pay for, they have these super lawyer designations. Those are just paid designations. I tell you, always go to your family and friends. Because they're going to be honest with you. They don't have any skin in the game, and they will tell you if they've had a good experience and how it's been. And I don't do any marketing intentionally. I don't do any marketing because I'm not just going to be out there, trying to get the Google ads and things like that. It's all word of mouth. It's all referrals from people. So that they feel confident, my neighbor used me or my sister. Or, I have some people, I have their entire families. I have mom and dad, I have all the kids. Then I get, a cousin. Um, Definitely use your friends and family for references. I don't recommend just going out there cold.
Thank
Um,
you, Tim. Yeah.
yeah. So again, back to the probate avoidance, account registration. We talked about that, doing your payable on death things, beneficiary designations, making sure you have not only your primary beneficiary, but contingent beneficiaries as well. Because if something happens to your primary beneficiary, you might not be thinking, I need to put a contingent on there. So making sure that you use all of those tools that you have available. Richard, I did an estate plan, and then my four sons use the same attorney as they grew up. Yes, absolutely. I'll tell you a funny story. And Chris knows the Twin Cities. So I'm down in Dakota County, which half of the county is farmland. And I've lived down there for over 25 years. And I found out that almost everybody is shirt tail cousins to everybody, and they all settled there in the 1800s. And so I have cousins and everybody. So I had a meeting where I was meeting with grandma and grandpa. And at that time, the grandson called me right before they walked in the door for something about his uncle. Now, I had all three of them, my grandma and grandpa, I had grandson, and I had uncle. And so I get off the phone, and grandma and grandpa come in, and we're talking, we're chatting, whatever. Well, lo and behold, grandma and grandpa were going over to grandson's for a barbecue, and uncle was there. And they said, they go, "Oh, we just saw Tammy and da 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 da." And grandson goes, "Well, she didn't tell me she was seeing you." So they all get on FaceTime. They're like, "What?" I go, "You guys, I can't tell you, but I have to be so careful because I've even found out people are related that I didn't know were related, but they keep referring me to each other in this group." And so it's nice though, because just like Richard said there, especially when I have the parents and the kids and they're doing it together, we can be sure that that's all very streamlined. I do encourage people, even if I'm not their children's estate planner, that we do at some point in time a family meeting to kind of let everybody know what's involved in the estate plan. Chris and I had Rose, um, and we had a client together, and he was very they're worth millions, but you wouldn't know it. He was very, very conservative, and he passed away, and Rose, his spouse, started spending money. She was giving money away. She was doing all this stuff, and I got a call from one of the children going, "We think mom has some dementia. She's just money is just going out the window." And I was like, "No, no, 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 no. Call Chris. Call Chris." So, and we had both encouraged them to talk to their families, and he just didn't want to. It was a private matter. So it is a hard thing to talk about sometimes. Estate planner versus lawyer. Um, so I will tell you, an estate planner has to be a lawyer, but a lawyer isn't necessarily an estate planner. The law has gone in the direction like medicine. It's gone in the direction of we do concentrations. So I don't do divorces. I don't do criminal law. I don't do personal injury. But you will still see lawyers that are a jack of all trade. So when you are looking for a recommendation, be sure that they say they concentrate on estate planning. Because there's an attorney I know, he's about 12 years older than I am, that he still does everything. One day he's in DUI court, and one day he is doing a divorce. And I would never dream of doing that. The nuances these days are so hard to keep up on that, to me, you can't be a jack of all trades and be good at what you're doing. You're in Minnesota. So Doug's in Minnesota. Oh, where are you, Doug? And have a will, and I've completed TODs, PODs on all my assets with the exception of licensed vehicles. Okay, here is the deal with the licensed vehicles in Minnesota. I only know this for Minnesota. Minnesota, this is the one thing the DMV does really, really well. You can do a TOD on your vehicles if you want them to go to specific people. But if you do not, heaven forbid you should pass away, as long as you have no probate, they have a very simple half form that you fill out at the DMV with the death certificate to transfer to one or more of the kids. So you can either do it now, which they do have a form that you fill out. It's a 2-page form. You take that form to the DMV with your original title. They'll issue you a new title that literally says on the title TOD and whomever you have. Or if you don't get around to doing that or don't want to pay the $21, it is very simple after your passing. It's the only thing that is simple with the DMV in Minnesota after your passing. I am not aware of that ability in South Dakota or Texas. I do know they have something similar in Tennessee as well. Good question.
So on the note of vehicles, one of the things that I have run into a few times is a spouse who doesn't understand that that vehicle is an asset,
Yeah,
and they turn around and sell it,
yeah,
even though there's going to be probate
yeah.
because
That,
they need
oh,
the extra cash. You can't do
oops.
that.
Yeah, nope, 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 not possible. When
So
you're,
what if a vehicle is? I'll let you read that question.
yeah. Yes. Okay. So Mike asked, when marrying a second chapter, is there a way to keep half of the current estate reserved for the first wife's kids, but still available for your use should you need it, for medical expenses? Yes. You can do this is a California question, but it's still the same. You can do an irrevocable trust. California is a community property state, but that community property starts, when that marriage starts. So if you know you're getting married, I recommend creating that irrevocable trust before you get married. Transfer those assets that you want into there. You are the lifetime beneficiary of that. So you can pull out what you need once you need it. But if you pull it out and commingle, now it becomes part of your community property. But you can do that irrevocable trust just to establish that separate property versus marital property. Texas is also, a community property state, and so that's what we do, in Texas when there's a second marriage in order to, protect some of those assets. And then Chris, my last slide, I have contact information on there, but I wanted to go back to the cost question. And you will see on there because I'm in Tennessee and I just did this presentation last week. So there's my Tennessee phone number. I also have a Minnesota phone number, but they go to the same phone. Um, so the cost varies, state by state. What I will tell you, I have no problems revealing my fees here. I do everything flat rate, and my flat rate also includes maintenance. So that annual check-in, which is very rare. So if I was working with a single individual just to do a will package, which would include their beneficiary designations, I charge $1,000. If we were doing, a single person, we were doing a trust package, which is the trust, the will, power of attorney, all of those things, I charge $2,500. Um, I am sometimes shocked, at how much people get charged. I will have people charged for that trust package in Minnesota, $4,000 to $4,500, and there's no maintenance and there's no funding. And so this is what happened when I was talking about Chris, the client that we had together. That's part of the reason Chris referred them to me because their estate planning attorney charged them, I think, $5,000, but they didn't fund the trust. There was nothing going to the trust. So the trust was moot. It wasn't worth the paper it was written on. And so I see that a lot with attorneys. And if they do the funding of the trust, they, charge the client extra for that. So I will say I'm unique in that. But do also, if you get referrals, do shop around and be sure you compare apples to apples. I will have some people come to me on the $1,000 package and say, well, I can get that for $600. And my question back to them is, but do you get updates? Because if you don't get updates, every time you go back to them, they're charging you a few $100s and your life is going to change. So be sure you do apples to apples. How much would you expect to charge to administrate an estate you had already put together? So I'm assuming this is once you have passed. If we're doing probate in Minnesota, I tell, clients, yes. If everything is done, I's are dotted and T's are crossed, it should only cost you $1,500 to $2,000. There's a filing fee in Minnesota of 325, and then there's publication fee of about 250. And if everything is put together really well, it should only be a few hours of the attorney's time. I charge $350 an hour. So if everything's put together well, it should never be more than $2,000. That's the other issue I've seen. I've seen attorneys charge $10,000. It seems insane. Does that include filing a state tax return? No. I will tell you, be wary of the attorney that tells you they know how to file an estate tax return. I know there are some attorneys that do it, but I would always, always have you go to an accountant. I don't file, the only tax returns, and Chris knows this, the only ones I file are nonprofit 990s because those are a little bit different and I know that law. But an estate tax return, you should always have an accountant do that. Do not have an attorney do that. Very rarely have I seen where that works out well. So I always say you should split those duties.
Tammy, can we go back to that vernacular funding a trust? I think a
Yes.
lot of folks don't understand. They get a piece of paper, it says you have a trust, and they don't realize that it's worthless until they actually fund it. Could you explain that process briefly?
Yeah, you need to actually move assets into the trust or make the trust beneficiary of assets. So again, I'll use Tennessee as an example. I actually deed the house into Tennessee. We actually go out, update beneficiaries so that the trust becomes the beneficiary, not people. We will sometimes move bank accounts or Roths or things into the trust. But if you don't have items put into the trust while you're living or have beneficiary designations that move things into the trust once you pass, nothing goes into the trust. And so what you will see a lot of times is a 5-page instruction letter from the attorney. Don't forget you need to do a deed to transfer the property. I've even seen this. I have one right now I'm working with. They had the client sign the deed and then handed the deed back to the client. It was never recorded. So I'm like, oh my goodness. And they thought it, and it's stamped copy, so it can't be recorded. So that's what I talk about funding the trust, an overflow trust. Are you talking about a will? Um,
Maybe a pour
a
over
pour
will.
over will, Andrew? So what a pour over will is what I draft when I tell you that every trust I draft gets a will, that's how we do it. So what would happen is if anything is missed getting into the trust, then we probate it and it moves over into the trust. And so we call that a pour over will. There aren't beneficiaries within the will. Funding the trust on death asset not yet put into the will. Yes, you can do that. Yeah. Absolutely. So we will do a lot of transfer on death deeds to trust. Why do we need to go through probate in Minnesota when all assets have PODs and TOD and there is a will for all? You do not have to go through probate. If all you have are household items, you will not have to go through probate.
What if there's a lot of debt?
If there is a lot of debt, you still don't have to go through probate.
Okay.
Absolutely. And one of the other things, I'm glad you brought up debt, Chris. Um, this isn't really an estate planning piece, but it's an awareness piece. Please be aware that you are not responsible for anybody else's debt. So whether it is your spouse, your children, you are not responsible for their debt. Their estate maybe, but you personally are not. And the reason I say that, and Chris and I have run into this so many times, a spouse will pass away and all of a sudden they get these nice letters from the creditors. Oh, Mr. So and so, we're so sorry about your loss. The balance on your wife's credit card was $3,276. Please let us know how you would like to settle that debt. You are not responsible for their debt. Absolutely not. The only debt you are responsible for your spouse are medical bills. That's the only thing. And you are definitely even medical bills. If you have an adult child that passes away, they will do the same thing. If that adult child was not married, you as the parent will start getting letters. We're so sorry on the loss of your daughter or your son. So I always tell people, please be aware of that. They technically aren't doing anything wrong. They're not saying you're liable for it, but it makes it seem that way. And sometimes Chris and I have been brought in, and our widowed person has already paid thousands of dollars towards this debt that they weren't liable for. So just beware, they will do it with children as well. Your adult children, if they aren't married, you may be getting these letters. If you are administrator of the
Tammy,
estate,
while you're on that, before you go
yeah,
to that next one,
yeah.
it comes up when are you responsible, like on a credit card, if you were not a joint owner, but you were a signer, like you were on the account as a user, that gets confusing for folks.
Yes. Yes. You have to be a joint owner of that credit card, not a signer. So, for instance, my two kids still have credit cards, emergency credit cards. I know they're adults, whatever. They never use them, but so they aren't an owner of the account. They're just an authorized user of the account. So if I pass away with money left on my credit card, my husband is not liable for it, nor are my children. So Andrew said, if you are administrator of the estate, doesn't the debt need to be paid? The debt needs to be paid if probate is opened. If probate is opened and there are assets available, and there are some exceptions to that, um, a house or the proceeds from the sale of a house is exempt from creditors. And there are some other exemptions. So if an estate is opened, debt may need to be paid, but maybe, not always. I had one estate I opened. The only thing in the estate was the house, the homestead in Minnesota, and there was about $50,000 worth of credit card debt. That house is protected from any debt, so the debt did not have to be paid. So it's always good to consult. I do estate planning and probate. Probably about 50% of attorneys do both. And then you'll have ones that do one or the other. I choose to do both. I try to get my clients to completely avoid probate, which I think makes me a better estate planner because I know the back end of it. But always consult a probate attorney. Bye, Richard.
Well, we have 1 minute left. So, Tammy, great job. It's just great to hear all this information, and it was great to see all the questions come rolling in.
Absolutely. I like
Yeah,
that.
really appreciate that. So, I think we will go ahead and close out. I think we got to most of those questions as we work through them. So, thank
Absolutely,
you
Mike.
for that.
Yes, Bill. Thank you
Again, I
for
want to thank you, Tammy. It's so great to see you again. We'll see you enough.
I
uh,
miss
but for
you.
sharing your time, your insight, your knowledge, your experience with us. Um, really appreciate that. And thank you, to guys who joined us live. Your presence, your questions, your willingness to engage, right, are what make this event a meaningful place for connection and guidance, right? So, a reminder that these events take place every month. There's usually one or two a month. So they're published on the website and in the monthly newsletter. So stay tuned, check them out. Registration, if you're a WSN member, it's free. It's always free. So you should take advantage of it. And many of you did tonight. So thank you. And finally, you're going to receive a brief survey by email. So just a few quick questions. Again, your feedback helps us continue to shape conversations that truly meet you where you are. And of course, we share that with our speakers. They appreciate that as well. So take good care of yourselves. Remember, you don't have to navigate this journey alone. Look forward to seeing you next time. Thank you and good night.